All those who can, please stand and join me. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Before we get to visitor and public comments, I would like to announce at 3:30 we did have an executive session to discuss legal matters. So at this time, I'll open it up to those who signed in to address the board. Please step to the podium, state your full name, address, and please try to keep your comments to 5 minutes. First up, we have Tom Beach.
I'd like to start by addressing the Curative Amendment. I just read through 28-page excerpt from the Curative Amendment procedures in Pennsylvania. The landowner's challenge to substantive validity of zoning restrictions. It appears to me that the concept of a Curative Amendment is inappropriate to the issue claimed by the petitioner. I'm not a lawyer or a legal scholar, but I can read. Failure by the landowner to follow the procedural requirements for a Curative Amendment is grounds for dismissal. His appeal to the court, which was demonstrated in Board of Commissioners versus Beto Development Company. The Commonwealth Court held that the appeal to the lower court should have been dismissed. The landowner had failed to notify the commissioners that he was challenging the validity of an ordinance and submitted a request for rezoning rather than a Curative Amendment. When a Curative Amendment is not appropriate, recent decisions of the Commonwealth Court 9 indicate use of the Curative Amendment procedure is inappropriate. According to these decisions, the Curative Amendment procedure cannot be used to obtain an appeal from a denial of a zoning request, or does not challenge the validity of a zoning ordinance, or to replace the variance procedure to have a court compel the adoption of a zoning amendment. In other words, he was denied an ordinance variance to ordinance. The court says you don't get a second bite at the apple. As an appeal of denial, an ordinary rezoning application Warren versus Fair. In Pennsylvania, it is settled that courts will not interfere with zoning classifications established by municipal governing bodies. These are legislative decisions, not judicial decisions. And Robin, Judge Kramer asserts that what is essentially a variance claim must go to the zoning hearing board since the request for a variance is required whenever a landowner desires to challenge the zoning of his particular tract through a claim, which, if established and reported, would warrant the granting of a variance. The landowner in Robin challenge the constitutionality of the ordinance as confiscatory as applied to his property. The court reached the merits of the challenge, affirming the findings of the township supervisors. Robin's property could be used for some purposes limited under R1 zoning. In other words, he can use his property, he can build houses on it, he just can't build the houses he wants. Zoning has failed to prove that the existing R1 classification has no substantial relation to public welfare. The court recognized that the Curative Amendment procedure allows for the landowner to submit a substantial challenge to the validity of zoning ordinance to the governing body with the right to appeal to the local court of common pleas, but upheld established law that the municipal governing body refusal to rezone is not subject to judicial review. Yet, it can provide definitive relief to successful challenge. The enactment of the amendment of zoning ordinance is purely legislative function, which is the courts have no power to review. A court may, of course, grant affirmative relief in the event of successful challenge pursuant to certain sections of the law, by ordering that the challenger's proposal plans be approved, but the court may not order property rezoned or a curative amendment be adopted. According to Alec versus Board of Supervisors, curative amendment submitted by a landowner is an offer to the governing body. No more. As we read, the 1972 amendment, the legislative intent of the proposed curative amendment is merely an offer or suggestion to the governing body, which will aid it in any attempt and may desire to make the cure a correct, effective ordinance. Now, his ordinance, curative ordinance he's asking for, is going far beyond the zoning issue of the multi-unit homes not having a side yard. That would be, under the curative amendment, the landowner must submit a proposal to amend the ordinance to cure the alleged defect. Not anything else, just the alleged defect. The alleged defect is common walled home and side yard, period. This would mean that we would need to, or look at to correct illogical or discrepancy or an ambiguous language in the ordinance, not what the petitioner is looking to ask by reducing frontages, lot sizes, etc., etc. If he doesn't want a 1,000-foot deep lot, don't make 20-foot wide homes. Make them 40-foot wide. Put two front-facing garages and an entry beside it. That gets you 40 feet. Now you're not 20-foot wide, you're 40-foot wide. He can still use that property. He can still build his homes on it. He just can't do it the way he wants. And the curative amendment only is to address alleged defects. There are no other alleged defects in the ordinance other than the multi-family units not having side yards. And that could easily be changed in the language. I thank you.
Mr. Beach. Next up, we have Chief Shosky.
Steve Kraskowski, 105 American School Road. I just want to make a couple points. The first one was this was not advertised correctly, because when I caught it, it said 6 o'clock on the township webpage and 6 o'clock on Facebook. And if I probably didn't correct it, it probably would stay there all weekend. Thing I want to do too is on a curative amendment. I think I remember him saying that we discriminated because we didn't have those type of townhouses in the township. We didn't stop him from building the 75 that he wants, or could have. He wants 125 because it's more financially feasible for him. The other thing too is, are we going to go over the adopted motion of a resolution 2020-515? Are you going to review that with us? Tell us what it's all about. In the same way, the alternative human amendment, you can explain what's going to be there.
Yes.
Okay.
Thank you. Next up is Jonathan Gardner.
All I have is just some plain common sense. You allow this to go through. There's another step towards Cranberry. Who's to say that somebody else is going to come along and buy out our property and build more townhouses? And what's next? Cheese's, a dollar store? We have a nice, peaceful community. I'm not against developing, but stacking up townhouses is not right. We'll just be in the same mess these people south of us are in. Another thing, why can't we have these meetings when it's feasible for people to come home, tend to their family, and come to the meeting? Why 4 o'clock?
Because we had to get out of here for the election people to set up tonight.
Could you what?
We had to get out, you see the election equipment, we had to get out of here for the election tonight. They come in and set up
So
tonight.
what's the rush? What's the rush?
Then
Postpone
we
it.
had
We have a window from the time we had the hearing.
I'm sorry, I'm very hearing impaired.
We have legally, we have a window from the time we had the hearing on the 20th, so when we have.
Tomorrow is the final day, we have to render a verdict by then.
This is a pitiful turnout. I don't know anybody in the township that's for this, except for maybe you guys. And what, for what, the almighty buck? You're gonna take a nice peaceful township and turn it into another Cranberry? That's what it's going towards. We already have people dumping stuff on our property. More people it's just gonna be like Cranberry. And besides that, they're not gonna move dirt in the winter, pull mud out on the road and everything. I don't see what the rush is on this. I really don't understand. Look, this is a pitiful turnout for this township. I live on a fixed income and it's not my likings to be on a fixed income, but I had to leave work early to come here today. I pick up a little bit of extra work to make ends meet. I had to leave early because this is at 4 o'clock. Now, I mentioned this at the 2 meetings ago, I mentioned this. So then I thought you guys were really listening. And the next meeting was at 6. That's a little bit better. We had a little bit better turnout. But then now look at this. We're back at 4 o'clock. This isn't you guys work for us. We pay you. It should be feasible for the people. And I think the people should take a vote on whether we want this or not. We're the ones that live in the township. We're the majority. And as far as I'm concerned, the people that do the paying are the bosses here. Now, this is not right at all. I try to get people to come here. I can't leave work. This is not right. You're not hearing the whole township when you got a pitiful turnout like this. As my understanding, the way it used to be was they had the meetings at 8:30 at night so people could get home, eat supper, tend to their families, and show up for the meeting. It's not like that anymore. It's 4 o'clock. That's ridiculous. Absolutely ridiculous.
That's all we have signed in. So we'll move on to the agenda, administrative business.
Okay, you're all aware there was a public hearing on the request for curative amendment on October 20th. The township ordinances require that proposed findings of fact, conclusions of law, and a decision be issued within 15 days. Needs to be done by resolution at a public meeting, so that's why we're here this evening. The record was received, the exhibits were received. We prepared, the township authorized preparation of detailed findings of fact. I believe there's 38 findings of fact, there are conclusions of law, and I just want to tell you that the Board of Supervisors and staff take all of your concerns very seriously. They listen to all of you, but they're also bound by Pennsylvania law, and there are restrictions as to what they can do and what they cannot do. And a review of the exhibits and the facts and the law, I'm going to summarize the findings, the final findings for you, and then the recommendation. So the township board did find that there were 3 defects to our ordinance as a matter of Pennsylvania law. Basically, we're excluding the viable and reasonable use of townhomes. So the $20,000 square foot minimum lot size for a townhome results in dimensions that are unreasonable and not viable. The 15-foot yard setback requirement is de facto exclusionary as applied to the party lines, and the 40-foot front yard setback is excessive and unreasonable. However, the township also found that it is not convinced by applicants' request for higher density. The township is recommending a maximum density of 3.25 units per acre, which is less than the advisory boards, but listening to the concerns of its citizens is what the township is looking to do. So the final conclusions, there are 3. Revise the current curative amendment zoning ordinance amendment to include 3.25 units per acre, and also incorporate the recommendations of the Buffalo County Planning Department dated October 14th, 25, that were admitted into the record. They had various suggestions as to just making our ordinance consistent. They also had no problem with the 3.250 acres in the curative amendment. Number two, refer this proposed zoning ordinance amendment back to the Butler County Planning Department for additional review, back to the Township Planning Commission for additional review, and then advertise for another public hearing and possible adoption of that zoning ordinance amendment. So those are the three recommendations that are part of this resolution. Again, the board took all of your comments very seriously, but they are bound to what Pennsylvania law requires. And so that is the resolution and findings of fact, conclusion of law, and recommendations that they will be adopting this evening. So you'll see the second motion, which is referring it back. So nothing's, we're not adopting anything this evening. We're taking it seriously, we're making those changes, sending it back to the two planning departments, and you will have another opportunity at a public hearing to express yourselves.
Questions? Move on to the administrative business. Seeking a motion to adopt resolution 2025-15, issuing findings of fact, conclusion of law, and decision.
I make a motion to adopt resolution 2025-15, issuing findings of fact, conclusions of law, and decision.
I will second that.
All in favor say aye.
Aye.
Aye, motion carries. Motion to refer the alternative curative amendment to the Butler County Planning Department and the Lancaster Township Planning Commission, and to advertise for a public hearing and possible adoption of the alternative curative amendment.
I make a motion to refer the alternative curative amendment to the Butler County Planning Department and the Township Planning Commission, and to advertise for a public hearing for possible adoption of the alternative curative.
I will second that.
All in favor say aye.
Aye.
Aye, motion carries. That concludes the agenda this evening's meeting. So at this time, I'd like to make a motion to adjourn.
Second motion to adjourn.
All in favor say aye.
Aye.
Aye, motion carries.